We had told you about the arrest of several Transnet executives in relation to a controversial 93 million rand locomotives tender. They are now appearing in court. Let's listen in.
Instructions from Mulabati. Is it okay?
Morning, Your Worship. I appear on behalf of Mr. Gama, who is the third accused on instructions of Galactia Incorporated. Thank you.
Good morning, Your Worship. I confirm my appearance on behalf of accused number 4, Mr. Johannesburg. I don't believe I've had the privilege of appearing in front of you. I apologize for also not introducing myself. I believe we do the introductions in court. As a court, please, Your Worship.
Thank you, Your Worship. Your Worship, this matter is the first appearance of the accused. They are all in custody. We want to deal with the issue of bail. Your Worship, the state submits that the accused have been charged with various offences ranging from contraventions of the Public Finance Management Act, contraventions of the Companies Act. There have been charges of fraud and corruption. Your Worship, the state submission is that this is a Schedule 5 offence. And in that regard, Your Worship, I do have a written confirmation by the investigating director, Advocate Andrea Johnson, which indicates and confirms that the charges the accused have been charged with, especially the fraud charge, is a Schedule 5 offence. May I have leave to hand in this document? Your Worship, the state is essentially not going to oppose bail. However, there are some issues that we would have to deal with, and that relates to especially accused number 1. His legal representative has contacted me and have also provided an affidavit to me. Your Worship, I'm not satisfied with certain of the submissions made in the affidavit. I would probably wait for accused counsel to arrive and she can ventilate that. We can decide what to do with accused number 1's bail application. With regard to accused number 2, we have the same position, Your Worship. An affidavit has been submitted. The statements made in the affidavit, Your Worship, require a detailed response from the state. And there are 2 issues fundamentally raised in his affidavit, the one applying for bail and the one discrediting the charges against the accused. So they're dealing on the one hand with the charges, indicating that they should not have been charged in this matter, as the accused has another matter that they're appearing before and the charges should be added. There's an issue of splitting of charges, but they want to deal with it in this bail application. So I would like to hear from them what is it that they want to do. With regard to accused number 3 and 4, they have presented affidavits to us, which we have read, and we are comfortable with the submissions made in those affidavits. On that basis, we are not opposing bail, and we will deal with accused number 3 and 4 separately if we need to. As it stands, Your Worship, the state indicated to counsel for the accused on Friday that the state does not intend opposing bail. The state has suggested an amount that the state believes is a reasonable amount given the severity of the charges in this matter. However, they disagree, so we'd have to deal with it on that basis. Your Worship, just one last submission is that in these sections, the certificate that I've just handed indicating that it's a Schedule 5 offence, that relates to count 5, where all 4 accused are charged on fraud, and the amount of the fraud that they've been charged for is in excess of 5 billion. To be accurate, it's 5.18 billion. So and it's on that basis, I believe my learned friends have not opposed that this is a Schedule 5 offence.
May it please the court, my lord. I am here. I think my attorney has placed on record that we accurate. Case number 1. May it please the court.
Your Worship, if I might be permitted, I know it's out of turn, but given the submissions by my learned friend for the state, in the sense that there's no challenge raised in our papers, the agreement, and of course I'm not suggesting that we're usurping your function, which is ultimately to decide on the amount and any other conditions that may be relevant to being imposed underlying their release on bail. Your Worship, we were taken by surprise. Being from the working class, I've got other arrangements for today. I've spoken to my learned friend for the state and my other colleagues, and if it so pleases your Worship and with your blessing, might we proceed with our applications, which appear to be uncontested, with the state so that we can wrap things up in relation to our clients. I did have the courtesy.
He has already addressed that, Mr. Babuch.
Sorry, your Worship.
He has already addressed it.
Yes, thank you.
So I don't have a problem with that.
I'm indebted. I'm then ready to proceed on behalf of number 3.
That's fine.
Might I proceed?
Not I said in this case when the letter is final, you said there are issues which you want to deal with. I just wanted to quickly respond. Thereafter we proceed with the matters which is.
Yes, certainly, Your Worship. My learned friend can address the court, and I'd like to hear what is her issues, because then we have to decide what to do with her matter.
May it please the court. Your Worship, as far as my client is concerned, and my learned friend is quite au fait with our position. I spoke to him on Friday as a matter of courtesy 2 times, and I again spoke to him this morning. We have an issue with the amount of bail. And in that regard, I believe...
The issue of bail is dealt by the court. It's an issue which is dealt with by the court,
Indeed.
not by any other person.
Indeed, my
So
lord.
there's no need to argue this matter before even the court hears the affidavit, the contents of the affidavit in support of the application.
So-
I'm not going to entertain it now. Thank you.
So I'm quite happy then that the other 2 counsel proceed in respect of the other accused, and then subsequently deal with the matter. May it please the court.
As the court pleases, Your Worship, as the onus is on the defence, may they present their affidavits.
Just before my learned friend proceeds, I know it's unprecedented to do this, Your Worship. However, may I kindly request, with your permission, Your Worship, that the accused persons be seated, since this might take long, as it is.
Mr. Babuch, you may proceed.
Thank you, Your Worship. Your Worship, it is indeed-
Sorry, Your Worship. What I think Your Worship meant is that perhaps we should start with accused number 1, with them presenting the affidavit, and then and we move forward.
I'm sure that Mr. Babuch wants it back, so let's allow him to deal with applicant number 3, and thereafter applicant number 4, and then come.
No objection. Thank you.
I'm indebted to Your Worship. Thank you. Your Worship, in discharging the onus that rests on my client, Mr. Gama, who has cited as accused number 3 in the charge sheet which we were provided this morning here at court, we have deposed to an affidavit in support of his application. These papers have been shared with the state, and with Your Worship's leave, might I hand up the original commissioned affidavit. I know that we have previously dispensed with the need, but I'm not sure about today. Shall I read it into the record, Your Worship? Thank you. I, the undersigned Siyabonga Innocent Gama, do hereby make oath and state as follows. Paragraph 1.1. I'm an adult male and the applicant herein. I'm a South African citizen born in Dundee, the province of KwaZulu-Natal, and I next here to mark A copy of my identity document. 1.2. I reside at 123 Ekurhuleni Crescent, Bryanston, Gauteng, 219 home, 291 referred to as the family home. This property is owned by a family trust that owns the shares in the company that owns the family home. I've resided in this property for the last 7 years, and it has a market value of approximately 29 million rand and is unencumbered. Para 2. The facts herein contained fall within my personal knowledge, save where otherwise stated, and are to the best of my belief both true and correct. 3. I've been informed that on 30 June 2025 I will formally be charged with offences including fraud, corruption, theft, as well as contraventions of the Public Finance Management Act, as well as the Companies Act 71 of 2008. I've been advised that these alleged offences fall within the ambit of a Schedule 5 offence in terms of the Criminal Procedure Act 51 of 1977. The allegations against me, brackets conveyed to my legal representatives by the NPA, close brackets, relate to my alleged receipt of large sums of cash from the Gupta family, as well as my purported involvement in the irregular procurement of 3 major locomotive contracts at Transnet SOC Limited, namely the 9500 and 1064 locomotives, collectively valued at approximately 50 or 60 billion rand. However, I have not been provided with an indictment or charge sheet detailing any charges to be proffered. Your Worship, I just want to point out that this affidavit was deposed to this morning already, prior to the annexes to the charge sheet having been given to us. And that's why there appears to be an anomaly, but it isn't. He actually deposed to this affidavit at the time of his arrest this morning. But we have since been placed in possession of the charge sheet. The state has indicated that the seriousness of these charges, as well as this being a further case brought against me, gives rise to concerns that I may attempt to evade any future trial. I unequivocally deny these allegations. I have at all times cooperated with the investigators of the matters in which I featured as a suspect, and I have complied with the conditions underlying my release on bail in the matter in which I was arrested in May of 2022. Para 4. In this affidavit, I deal with my personal circumstances and the allegations levelled against me, brackets, insofar as they are known to me, close brackets, and the factors to be considered by the Honourable Court as contained in section 60 sub 4 to sub 9 of the CPA. 5. I'm advised that 5.1. The present alleged crime is an offence which falls to be listed in Schedule 5 of the CPA. 2. In terms of the provisions of section 6011B of the CPA, I am required, having been given a reasonable opportunity to do so, to adduce evidence which on a balance of probability satisfies the above Honourable Court that the interests of justice permit my release from custody. And 3. I bear the burden of proof and that I am obliged to initiate this application. I, however, reserve my right to respond to any evidence and allegations placed on record by the state during this application. 6. Personal circumstances. 6.1. I am 58 years of age. 2. I am divorced and have 11 children born from 2 unions. Of the 11 children, 6 are minors for whom I provide maintenance and support. One of the children, who has attained the age of majority, is a full-time student, and I provide ongoing maintenance to her. 3. Most of my family members are resident in the Republic of South Africa. However, my one sister, together with more distant relatives, reside in the Kingdom of Eswatini. 4. I am a minority shareholder in a corporate structure which intends to acquire immovable property in the Kingdom of Eswatini. However, the acquisition aforementioned has not come to fruition. 7. Income, occupation and assets. 7.1. I'm currently serving as a Member of Parliament. In this capacity, I receive a remuneration package in accordance with the applicable parliamentary salary scales and benefits, in addition to my parliamentary responsibilities. Sub 2. I further have interests in various business ventures, including investment vehicles with exposures to assets listed on the Johannesburg Stock Exchange. These business interests supplement my income and form part of a broader investment structure from which the entities receive dividends, and I make periodic drawings. 7.3. Immovable and movable property. I own the following immovable properties. Sub 1. Unit 503 Marine Port, 27 Timeball Boulevard, Point Waterfront, Durban, with a market value of approximately 2.5 million. There is a bond registered in favour of Standard Bank over this property for approximately 1 million rand, and Unit 204 Legend Golf and Safari Resort, Entabeni, Limpopo, which has a market value of approximately 11 million rand. This property is unencumbered. I own movable assets including furniture, household effects and jewellery valued at approximately 6 million rand. I am a registered taxpayer and next year to Mark B a copy of the breakdown of my assets and liabilities prepared by my auditor and submitted to SARS in 2020. There have been no significant changes to the assets listed in Annexure B. 8. I am able to post bail in the amount of 200,000 Rand and will submit myself to any reasonable conditions underlying my release on bail imposed by this Honourable Court. 9. The alleged offence. As stated here and above, the detail of the charges which have been proffered against me have not been disclosed to me in the form of a charge sheet or indictment. Neither have I or my legal representatives been permitted access to the South African Police case docket, so as to enable me or my legal reps to deal meaningfully with the charges proffered against me. The investigating officer in this matter, Captain Willem Bekes, informed my attorney and me that the charges currently brought against me pertain to the procurement process relating to the so-called 95, 100 and 106.4 locomotives at Transnet, a matter which has been the subject of extensive public scrutiny and which investigations I personally initiated and instituted. At the time of the 106.4 locomotive procurement process, I was serving as a senior executive at Transnet. While I held a leadership position during this period, it is not the purpose of this affidavit to provide a detailed account of the broader procurement process or internal decision-making structures. However, I place on record that I deny, in the strongest possible terms, any wrongdoing on my part in relation to the locomotive procurement whilst I served as a senior executive during the relevant period. 9.2. I was made aware that a warrant had been issued for my arrest when Captain Bekes contacted my attorney directly to inform me of the warrant and to make arrangements for my voluntary surrender. Following consultation with my legal representatives, I confirmed my full cooperation with the authorities. Pursuant to this, it was agreed that I would present myself on 30 June 2025 at 0800 hours at the Brackendowns police station near Alberton. My aforesaid undertaking was fulfilled and I was taken into custody. I wish to place on record that I have always made myself available to the authorities and have acted responsibly and transparently upon being made aware of the investigation. 9.3. I have also cooperated fully with the authorities in a separate but related matter since my initial arrest in May of 2022. I have strictly adhered to all bail conditions imposed underlying my release on bail. In fact, I have on no less than 4 occasions formally applied for my bail conditions to be amended to permit me to travel internationally. On each occasion, I motivated my applications for said relaxation without opposition from the National Prosecuting Authority, and I have at all times complied with the amended conditions, including having returned to the RSA following my departure. 10 previous convictions. My legal representatives have explained the provisions of Section 6011B of the Criminal Procedure Act 51 of 1977 to me. I confirm that I have no previous convictions. Whilst I have been released on bail, in a related matter that is currently pending before the High Court Johannesburg under case number SS75 of 2023, I have complied fully with all conditions imposed by the court in that matter since my release. The charges in that case arise from the same overarching investigation and would appear to be closely related to the present matter, and the allegations against me featured prominently at the Zondo Commission, and I contested same strongly throughout my engagement with the Commission. I have thus known about the allegations for several years. I have done nothing whatsoever in any manner of means to interfere with the state investigation. I have no intention to do anything which may be viewed as an attempt to influence the said investigation. Sub 2. I have not been released on bail in respect of any unrelated or separate matters. In the present instance, this affidavit serves to support my application in terms of Section 60 of the CPA. I respectfully submit that my track record of compliance with all conditions demonstrates that I am not a flight risk and that I will attend a trial if released on bail once more. Paragraph 11. Add Section 64, subparagraph A, read with Section 60, subsection 5 of the CPA. I undertake not to make contact or communicate with any of the state witnesses and request that their identities be disclosed to me so as to enable me to purposefully not make contact with them. I have no disposition to commit any offences. Accordingly, I submit that there is no likelihood that if I am released on bail, I will endanger the safety of the public or any person, and or I will commit a Schedule 1 offence. Paragraph 12. My occupational, emotional and family ties are within the Republic of South Africa. I have valuable movable and immovable property in the Republic of South Africa, I have no desire or intention to leave that behind to endeavour to escape a trial here. I have travelled extensively throughout the Republic of South Africa and abroad. Even though I was aware of the allegation that had been levelled against me, I have made no attempts to flee from the Republic of South Africa. I respectfully submit that the facts set out above support my submission that I do not constitute a flight risk. Should I be so ordered, I will not leave the Republic of South Africa. However, if I'm permitted to leave the Republic of South Africa, I will do so in compliance with conditions imposed by this Honourable Court. I have appeared no less than 13 times before this Honourable Court and the High Court of South Africa whenever directed or arranged with me to do so. These appearances reflect my ongoing compliance and cooperation with the court processes over a substantial period of time. I have consistently respected the authority of the courts and have never failed to attend any hearing. This extensive track record is conclusive evidence that I do not pose a flight risk. I have already surrendered both my valid South African passport and my official passport to the state. I confirm that I will not apply for any further travel documents pending the finalisation of the trial. This undertaking is made in full recognition of the provisions of Section 60 of the CPA and in support of my commitment to comply with any and all bail conditions imposed by the court. Although I accept that the charges against me are serious, I reiterate that there is no need for me to attempt to evade justice. My livelihood is dependent upon me being in the Republic of South Africa, and I cannot afford to become a fugitive of justice. I will submit myself to any reasonable conditions which may be imposed by this Honourable Court, and I respectfully submit that there is no likelihood that I, if released on bail, will attempt to evade my trial. Paragraph 13. I'm given to understand that the evidential material which the state relies upon is in the possession of the investigating officer and that it is safely secured. I'm furthermore not aware of the existence of any other exhibits or material relevant to the state's case which can be concealed, and I will most definitely not conceal or destroy any evidential material. 14. I respectfully submit that there is no likelihood that I, if released on bail, will undermine and or jeopardise the objectives of the proper functioning of the criminal justice system, including the bail system. 15. I respectfully submit that should I be released on bail, my release will not induce a sense of shock or outrage in the community, and I will not disturb the public order or undermine the public peace or security. I further submit that my safety will not be jeopardised by my release on bail. 16. I respectfully submit that the interests of justice do not require my continued incarceration. Furthermore, I respectfully submit that I have discharged the burden which rests upon me to demonstrate that the interests of justice permit my release on bail. 17. I stand to be severely prejudiced by my continued incarceration. I'm advised that the state intends to request the Honourable Court to direct that I post bail in the amount of 200,000 rand, based on their perception that I may constitute a flight risk. I respectfully submit that the interests of justice, considerations of prejudice, and the balancing of respective interests favour my release on bail on such conditions as this Honourable Court may impose. Your Worship, the affidavit deposed by my client and duly commissioned has been handed up to Your Worship. I was not in attendance, but I'm sure that my client will now confirm that he is the deponent to the affidavit. Thank you, Your Worship.
Mr. Duncan, do you confirm the contents of the affidavit in support of the application read and edited by counsel?
Yes, I do, Your Honor.
Affidavit accepted with matter 8.
As the Court pleases, applicant's case, Your Worship.
Thank you. Case for the applicant. Mrs. Moore.
As the court pleases, Your Worship, we are ready to proceed with the formal bail application, and we've also prepared a bail affidavit. I beg leave to hand sign up to Your Worship. I proceed to read same into the record. I, the undersigned, Tamsani Gianni, do hereby declare under oath as follows. Point 1. I'm a major male and the applicant in the above mentioned matter, duly authorized to depose to this affidavit with the following personal particulars and background. 1.1. Identification number. My identification number is 740504554588. 1.2. Date of birth. I was born on the 4th day of May 1974. I'm 51 years old at the time of deposing to this affidavit. 1.3. Citizenship. I'm a South African citizen with the identification number. I'm not going to repeat that. A copy of my identity document is attached here to mark as Annex A. 1.3.1 travel documents of an expired South African passport under passport number E00083428. I endeavour to hand over same should it form part of the bail conditions imposed by this honourable court. A copy of my passport is attached here to mark as Annex B. 1.3.2 previous travel or residence in a foreign country. I've not travelled outside to any foreign country since the year 2018. Prior to 2018, I travelled outside of the Republic of South Africa for purposes related to business operations with Transnet. The details of these business-related travels are as follows. In 2009, I travelled to the Netherlands. In 2011, I travelled to India, China, and Japan. In 2012, I travelled to China. In 2015 to 2017, I travelled to Nigeria, Mozambique, Zimbabwe, and Kenya, and the Republic of Congo. 1.3.3 relatives resident outside the Republic of South Africa. I have no relatives residing outside of South Africa. 1.3.4 assets outside the Republic. I have no assets outside the Republic of South Africa. 1.4 1.4.1 or 1.4 personal background. 1.4.1 place of birth. I was born in Ekurhuleni, KwaZulu-Natal, South Africa. 1.4.2 schooling. I attended Ekurhuleni High School in Ekurhuleni from 1990 until 1992, the year I matriculated. 1.4.3 tertiary other training from 1993 to 1995. I obtained a secondary teacher's diploma at Indomisu Teacher Training College in Maritzburg. From 1997 to 2000, I completed a Bachelor of Business Administration degree at the University of Natal, Maritzburg. Between 2000 and 2005, I undertook various short courses in supply management through Transnet, and from 2005 to 2009, I obtained my master's degree in business leadership from the University of South Africa. 1.4.4 work history. From 1996 until 2000, I was employed on a contract basis as a teacher facilitator at Indomisu Training College. From 2000 until the end of 2001, I was employed by Transnet in Saldanha Bay as a commodity officer. From 2001, I was promoted to the position of junior procurement manager at Transnet, also based in Saldanha Bay, serving in this capacity until the end of 2003. From 2004, I was transferred to Transnet's Parktown office, continuing in the role of junior procurement manager, serving in the capacity until the end of 2006. In 2007, I was promoted to the position of senior procurement manager at Transnet Parktown, a position I held until the end of 2011. In 2012, I was promoted to the position of chief procurement officer at Transnet Parktown, serving in this capacity until the end of 2014. In 2015, I was appointed as the Chief Executive Officer of the Engineering Division at Transnet, serving in this capacity until the end of August 2019. Since the termination of my employment at Transnet, I've been farming commercially in Ekurhuleni, Newcastle, in the Ekurhuleni, Newcastle area, at Komdai Farm, of which Dust Commander Pty Limited is the sole owner of. 1.4.5 general remarks regarding background and permanency. I've been living in the Republic of South Africa for my entire life, and I have no plans or desire to relocate elsewhere. 1.5 current status. 1.5.1 address. I reside at 13 Peacock Lane, Kyalami Hills, extension 8 Midrand, 1685. A copy of my proof of residence is attached here to marked as Annex C. 1.5.2 marital status and general particulars of spouse. I'm married to Goodness Tanazile Gianni, a 51-year-old female, and we've been married since 2003. Our marriage has produced two children, namely Mumpelo Gianni, my 22-year-old son, and Siabulela Gianni, my 13-year-old son. I also have the following children: Minele Dlamini, a 32-year-old male who is my stepson. He is the biological child of my wife from a relationship prior to our marriage. And Tembutele Gianni, a 26-year-old female who is my biological daughter from a previous relationship prior to my marriage with Goodness, Tanazile Gianni. 1.5.3 dependents. The following persons are my dependents: Mumpelo Gianni, my adult major son, and Siabulele Gianni, my minor son, and Safiso Kumalo and Simandla Nkomezulu, my nephews. 1.5.4 occupation. I'm a farmer at Komdai Farm in Ekurhuleni. 1.5.5 other source of income. I have no other source of income. 1.5.6 assets. I'm the registered owner of the following immovable properties: a residential property situated at 13 Peacock Lane, Kyalami Hills, extension 8 Midrand, 1685, and a farm known as Komdai Farm, located in Ekurhuleni, KwaZulu-Natal. Attached Year 2 and marked as Annexure D is a copy of my statement from Danhausen Municipality to Task Commander Pty Limited, of which I'm the sole director of, and confirming I make regular payments in respect of the Kromdraai farm. Attached Year 2 and marked as Annexure E is a copy of all the documentation relating thereto. In addition to the above immovable properties, I'm also the owner of the following movable assets: a 2-ton truck bearing registration number BB68BV ZN and 2 Landina farm tractors. 1.5.7 availability and source of funds for bail. I can afford to pay bail in the amount of 100,000 rand. 2. History of antisocial behavior. 2.1 previous convictions. I have no previous convictions. 2.2 pending criminal cases. I have no other pending criminal cases. 3. Arrest and factual background thereto. 3.1 date of arrest. I was arrested on the 30th day of June 2025 at Brackendowns Police Station. 3.2 offence charged with. I've been notified that I'm being charged with theft and fraud in the amount of approximately 60 billion rand. Apologies, Your Worship, this was also included and opposed to before we received a copy of the charge sheet. 3.3 intended plea. I intended plea not guilty to this charge. 3.4 defence. I've been informed of my right to remain silent at this stage and not to disclose the basis of my defence. However, whilst I've been informed of my rights and advised of my right to remain silent, I wish to deny the allegations levelled against me and to reserve the right to respond to whatever allegations the state might make during the bail application proceedings. 4. Submissions regarding facts to be considered when deciding whether bail should be granted. 4.1. Schedule of the Criminal Procedure Act 51 of 1977. The matter resorts under. I've been informed that my charge of theft and corruption to the value of approximately 60 billion rand falls under Schedule 5 of the Criminal Procedure Act. 4.2. Considerations in terms of Section 60 sub 4 A to E. I'm further advised that in considering whether to grant an application for bail, the court will consider the relevant factors in Section 60 sub 4 of the Criminal Procedure Act. 4.2.1 Section 60 sub 4A. Danger to the public or individual safety. I respectfully submit that my release on bail will not endanger any person's safety. I harbour no resentment against any individual or the public in general. 4.2.2 Section 60 sub 4B likelihood of evasion of trial. I respectfully submit that this likelihood does not exist. In view of my personal profile as set out here and above, as well as since I cooperated with the police officials. I was informed on Thursday, 26 June 2025 that I'm being charged. Upon receiving this information, I immediately took steps to make myself available to the investigating team. I respectfully submit that I voluntarily and willingly handed myself over to the investigating team. I have no intention whatsoever of evading my trial or obstructing the course of justice. I do not wish to evade my trial and live the life of a fugitive. I do not have the means, financial or otherwise, to live the life of a fugitive. 4.2.3, Section 60 sub 4C, interference with witnesses or evidence. There is no likelihood of me interfering with witnesses in this matter. I have no access to the evidentiary material held by the investigating officer. I further undertake not to interfere with any of the state witnesses or attempt to intimidate them. 4.2.4 Section 60 sub 4D, jeopardy to the functioning of the criminal justice system or bail system. Given all the above considerations, I submit respectfully that I pose no danger to the functioning of the criminal justice system or the bail system. I have not furnished any false information for purposes of this application or after my arrest. 4.2.5 Section 60 sub 4E, exceptional circumstances, presence or absence which may lead to undermining public peace, the public order or peace. I respectfully submit that there is no exceptional circumstances which may lead to the undermining of public order or peace should the court decide to grant me bail in this matter. 4.2.6 the provisions of Section 60 sub 9, the interest of justice in relation to the right to be released on bail. I respectfully submit that I'll be severely prejudiced in the event of being further detained. I also urge this Honourable Court to consider the period I'm to be detained until this matter is finalised and the fact that criminal trials can take a considerable period of time before they are finalised. Furthermore, I urge that the Honourable Court consider that I will not be able to continue farming and earning income from farming during my period of detention. I also urge upon this Honourable Court that should I be detained and refuse bail, that I will be prejudiced in preparation for my defence. I've been advised that it's extremely difficult to consult with legal representatives inside prison, and I have no doubt that my continued detention will seriously jeopardise my preparation for my trial. Apart from the fact that my period of detention cannot be estimated with any form of precision at the moment, I request the Honourable Court to take into account that I will not earn an income while so detained. I therefore stand to suffer considerable financial loss and will be unable to look after my dependents. 4.2.7 other relevant factors to be considered by the court. I respectfully submit that the interest of justice permit my release on bail and that I am therefore entitled to be admitted to bail. I submit further that I'm not a flight risk and I'm willing to abide by any conditions the court may deem fit to impose. In the premise, I respectfully submit that the court should grant me bail in the amount of 100,000 rand and with such conditions attached as the court may deem fit. I believe my client will now confirm that he has proposed in this affidavit.
Do you confirm the contents of the affidavit as read by the attorney?
Yes, I
To
do.
support the application. Affidavit accepted and marked exhibit B.
That's the case for the application.
May I please support, my Lord? My Lord, we have prepared an affidavit. I beg leave to hand up the original to the court. And I ask for leave to read the content so your Worship can follow. May I proceed, Your Worship? Thank you very much. I, the undersigned Anop Singh, do hereby make oath and state as follows. I'm an adult male residing at Block 23, Unit 4, Phoenix View Estate, corner of 14th and Riverside Road, Noordwijk, Johannesburg. My identity number is 730809517689. The facts contained are, in the best of my knowledge, true and correct, and are otherwise indicated in my personal knowledge. Paragraph 3, insofar as I rely on allegations of a hearsay nature, I state that I believe them to be both true and correct. 4, when I make legal submissions, I do so on the advice of my legal representatives, and I accept same to be correct. 5, I've been informed that I will be formally charged with various offences related to the procurement of locomotives while I was in the employ of Transnet. These allegations arise from inter alia forensic investigations by M&S attorneys and the investigative directorate of the NPA. Your Worship, I just want to pause here to indicate to the court, as stated by my previous learned friends, we've only been provided with an indictment this morning, and for that reason we did not allude any more to the content of the indictment or the charge in 6. I've been advised with advice accept that Schedule 5, read to Section 60(11)(b) of the Criminal Procedure Act applies to my bail condition. I further advise that in terms of the provisions of Section 60, sub-11, sub-b of the CPA, and in amplification of my application to be released on bail, but this all that I must satisfy the court that the interest of justice permits my release. 7, in this regard, I wish to bring the facts set out here and below before the Honourable Court for due consideration. 8, I structure the affidavit as follows. Sub 1, firstly, I deal with my personal circumstances, and 8.2, I deal with the factors listed in Section 60, sub 4. Personal information, 9, I'm a South African citizen, ID number is stated above. My date of birth is 9 August 1973, I'm 51 years of age. 10, my place of birth is Tongaat, KwaZulu-Natal. I attended Imona Primary School in Tongaat from grade 1 to 6, Victoria Middle School from 7 to 8, and Tongaat Secondary School from grade 9 to grade 12. 11, I thereafter attended the University of KwaZulu-Natal, as is more fully amplified below. 12, I was married to Selina Esther Singh, Selina, my second ex-wife, on 2 July 2020, which marriage was recently dissolved by an order granted in the High Court Johannesburg on 14 March 2025, with who I share one child. 13, as aforesaid, I presently reside at the address cited above since 29 January 2024. This property is owned by my mother, Sarawati Singh. I duly informed the investigating officer, Denwell Kutsia, of my change of address when I moved to the said property. I attach a copy of the email my attorney addressed to him on the said date. 14, I was also previously married to Diana Singh, my first ex-wife, with whom I share 2 children born from the said marriage. My children are sub 1, Akhil Singh, 22 years of age, resides with Diana in Durban, KwaZulu-Natal. Sub 2, he's self-employed. Sub 3, he visits me regularly. I'm responsible for paying his medical aid. Sub 2, Alicia Singh. Sub 1, she is a 14-year-old girl. She's in grade 10 and is enrolled at Paragym Educational Centre, Durban. She similarly resides with Diana. I regularly visit and have contact with Alicia as well. Sub 2, Sub 3, I'm responsible for paying the school fees, medical aid and other expenses. Araya Singh, she is a 4-year-old girl born from my second marriage. Araya currently attends school at Piccolo Early Learning Academy and resides with my second ex-wife in Durban. Sub 2, she is emotionally dependent on me. Paragraph 16, my mother is Sarawati Singh, an 84-year-old pensioner who currently resides at Unit C23-04 Phoenix View Estate, corner of 14th and Riverside Road, Noordwijk. My mother is old and frail and dependent on me for financial support. My father is deceased. 17, I have 3 older sisters. My sisters are all married and have families of their own. 18, I also have extended family who lives in KwaZulu-Natal. 19, is clear from the aforesaid that my family all live and work in South Africa. Employment history, I obtained a Bachelor's of Accountancy degree from the University of KwaZulu-Natal in 1995. I also obtained a postgraduate diploma in accountancy in 1996 from the University of KwaZulu-Natal. 21, I served articles with Deloitte & Touche between 97 and 99. 22, I worked at the as the divisional financial manager of SPAR, KwaZulu-Natal, from March 2000 to December 2002. Paragraph, between January 2003 and April 2005, I worked at Transnet, a state-owned entity known as Spoornet, as the senior financial manager at Freight Rail Division. 24, during May of 2005 and March 2009, I was employed at Transnet capital S, capital O, capital C Limited as the Group Corporate Centre General Manager, Group Financial Services. 25, from about 2009 to 12, I was the Acting Chief Financial Officer of Transnet, capital SOC Limited. 26, between 2012 and 2015, I was appointed the Chief Financial Officer of Transnet, capital SOC Limited. 27, from 2015 until my resignation in 2018, I was the Chief Financial Officer of Eskom. 28, I've been unable to find any fixed employment since my resignation from Eskom due to what I said is false allegation that I was involved in criminal activities. 29, I have however managed to secure temporary employment with Labat Healthcare as a financial advisor. I started with them in June of 2024 and I earn approximately 50,000 Rand per month. I will, during my address to the court, deal with this aspect a bit further. Assets and liabilities. 30, Dormel Pty Limited investment, 15 million, sub 1. This investment cannot be liquidated. 31, Smith and Noordling investment, 800,000, sub 1. This investment cannot be liquidated. My learned friend doesn't have that in. We've amended it, and I will make sure that he gets a signed copy of that. 32, legal expenses in the amount of 3 million. And 33, I have no assets or liabilities outside of the border of South Africa. Travel documents. I have 2 valid South African passports. I've surrendered both passports to the investigating officer, Colonel Denville Kutsi, upon my release on bail in August 2022, in case number SS785/2023. History of previous convictions. I've got no previous convictions. 36, I have 1 pending criminal case which is currently enrolled for trial, February 2026, as stated above. Paragraph 37, I've been arrested once before in connection with the matter referred to above and released on bail. This matter is set down for trial in the High Court, Johannesburg, for commencement in February of 2026 and relates to allegations of offences committed during my employment at Transnet. I was arrested in respect of this matter on 29 August of 2022, released on bail on the same day on the following condition: that I pay an amount of 50,000, sub 2, that I appear on every date the matter is postponed to, sub 3, that I hand over both my South African passports to the investigating officer, sub 4, that I approach the state and the investigating officer directly for purposes of ad hoc requests to travel outside the borders of the Republic of South Africa and for the return of my passport. 37, the passports holding the numbers M0021-300-02 and M0909-0109-148 duly handed to the investigating officer, Colonel Denville Kutsi. 38, since my release about a year, all bail conditions in respect of the aforementioned matter. My Lord, we then deal with, Your Worship, I then deal with the considerations in terms of section 60, sub 4, sub A to sub E. I hereinafter now deal with those. Paragraph 39, section 64A, danger to the public or individual safety. It is evident inter alia from my past conduct and the fact that I do not have any previous convictions whatsoever that I do not pose any risk to the safety of the public in general or the safety of any specific individual. I further submit that it's evident from my past conduct that I do not have any predisposition to commit offences referred to in Schedule 1 of the Criminal Procedure Act or any other offences. 40, 60 sub 4 sub B, likelihood of evasion of trial. Paragraph, there is no likelihood that I will evade my trial if released on bail. I further submit that the fact that I will not evade my trial is further supported by what is set out in this affidavit. I further proven through my conduct after my release on bail in the matter referred to above that I will attend to court and adhere to my bail conditions if released on bail. I have in fact attended court on each date the case was postponed to. I further returned to South Africa on each occasion I was granted permission by Colonel Daniel Smith to travel abroad. I have every reason to remain in South Africa and stand trial. Fleeing is not an option to me. I submit that the idea of becoming a fugitive for the rest of my life and to live continuously on the run apart from my family is ridiculous. I'll never do such a thing. I submit that it is evident from my personal particulars, which have been sketched in some detail above, that I have strong family, community and occupational ties for Gauteng and KwaZulu-Natal. I was born, raised and schooled in these areas. I've resided in these areas all my life. I deny that the state will succeed in establishing my guilt on the charge. Sub 2, as mentioned before, the first application for the return of my passport and the court's ruling thereon in the matter is a matter of public record. After what transpired in court, my passport was returned to me on 2 more occasions, and I travelled to the UAE on Saturday the 11th of February and returned to South Africa on Tuesday the 13th of February. At all relevant times, the state knew the purpose of my travel to the UAE at the time to meet representatives of A&M accountants to discuss strategic business opportunities and investments the company identified. Upon my return, I duly handed my passport back to Colonel Coetzee. I emphasized the fact that I adhered to the arrangement with the state. But sub 3, I also had my passport returned to me to travel to Zimbabwe between 10 and 20 May. Subsequent to my attorney, Mr. Matopo, addressing a letter to Colonel Coetzee, I duly left and returned as per the arrangement with the state. Paragraph 4, on 4 August 2023, I deposed an affidavit at the request of the state to return my passport yet again to travel to the UAE. My request was granted by the state and my passport was returned to me. I thus left South Africa on the 15th of August 2023 and returned on 23 August 2023. Upon my return, I duly handed my passport back to Colonel Coetzee. Sub 5, it's abundantly clear from what transpired that the states at no stage regarded me as a flight risk. My past conduct established beyond any doubt that I'm not a flight risk if I am to be released on bail. 64C, interference with witnesses or evidence. I'm aware of the identities of potential state witnesses due to the Zondo Commission hearings. Documents and statements disclosed to me during the hearing and the previous criminal case that set down for trial in 2025. I do not know the whereabouts of any evidence which the state intend to rely on in the trial of this matter, which has not been given or disclosed to me as explained above. I further submit that there is no likelihood that if I'm released on bail that I would interfere with the witnesses or evidence. I nevertheless undertake not to interfere with any state witnesses. If I am provided with a list of such witnesses, I furthermore not interfere with any of the witnesses in relation to the matter set down for trial in February of 2026. 60 sub 4 sub D, jeopardy to the function of criminal justice of bail system. Sub 1, I submit that I did not supply the investigation of the case with any false information pertaining to my arrest. I furthermore submit neither did I supply the Honourable Court with any false information pertaining to this application. I therefore submit that there is no likelihood that if I'm released on bail, my release will jeopardise the proper functioning of the criminal justice system and or the bail system. 60 sub 4 sub E, exceptional circumstances present or absent which may lead to the undermining of the public order or peace. I respectfully submit that no legal basis exists to allege that my release on bail may lead to the undermining of the public order or peace. 60 sub 9, weighing up the interest of justice against my right to personal freedom. Sub 1, I submit that my incarceration awaiting trial will prejudice me in the extreme in that I'm likely to stay in custody for lengthy time in view of the fact that it may be a matter of years before the matter finally comes to trial. I also addressed the court on this particular issue during my submissions to court. I undertake to attend court on each and every postponement hearing, pending further investigation for the trial of this matter and the trial that may ensue. Sub 3, I submit that if I remain incarcerated, I will undoubtedly suffer serious financial loss because of the fact I will not be available to attend to my family responsibilities and other financial commitments. The financial loss should I be incarcerated would be irreparable, and I have far-reaching consequences on me and my family. So, 4, I further submit that my incarceration and continued detention pending trial will not be in the best interest, of justice. I submit that it will be in the interest of justice for me to be released on bail in order that I may earn a living to support all my dependents set out above. I will not be separated from my children, my mother, my family, who I love dearly without due cause. Lastly, I submit my incarceration will seriously affect my trial preparation, not only in this case, but also in the case which commences on February 2026. Again, I will address the court on this issue during my submissions. Bail amount. Argument will be addressed to the Honourable Court during the hearing of this bail application for my release on warning. The crux of such argument will be the following. Sub 1. The salient facts in this case is an extension of and inextricably linked to the facts in the High Court matter mentioned above. The charges I believe will be levelled against me could in fact have been added to the charges I face in the indictment. This matter, sub 2, this is a matter on which I should have been summoned to appear in court in terms of the provisions of Section 54 of the Criminal Procedure Act, which would have resulted in me being warned to appear in court after my appearance. Full legal argument will be addressed to the court on the aforesaid during the hearing of this matter. It was duly then commissioned, and we pray, of course, for the court to release us either on warning, alternatively on bail, duly deposed to and signed and sworn to 30 June of this year. May I then beg leave that the court accepts this affidavit as an exhibit. I believe the next one will be Exhibit C. May it please the court.
Do you confirm the contents of the affidavit as arrived in support of the bail application? I do, sir. It's accepted and marked Exhibit C. Mr. McCarthy?
May it please the court, Your Worship. We do confirm that the matter falls within the ambit of Schedule 5, and likewise we have prepared an affidavit which has been deposed to this morning, and I also wish to put it on record that we only were appraised with the charge sheet this morning here in court. I beg leave then to read Mr. Mulife, accused number 2's affidavit into the record now.
May I hand in the original?
May I read it into the record now?
May you hand
The affidavit. I'll hand in the commissioned one, which I will then request that it be marked as Exhibit D. It reads as follows, Your Worship. I, the undersigned Brian Mulife, do hereby make oath and state that, introduction and purpose, I am a 58-year-old adult male and South African citizen residing at house number 7, The Ridge Street, Zwavel Nest Estate, Zwavelpoort, Pretoria. By virtue of employment as a member of the National Assembly for the Umkhonto weSizwe political party, situated at 120 Plain Street, Cape Town, with effect from August 2024. I also reside at Acacia Park Parliamentary Village during parliamentary sessions, which is situated at Townsend Street, Woodwood, Cape Town. 3. I'm an accused in the criminal matter pending before this honorable court as per charges delineated in the charge sheet and the applicant herein. 4. The facts deposed herein fall within my personal knowledge and belief and are true and correct unless the contrary appears or the context indicate otherwise. 5. Where I make submissions of law, I do so on advice of my legal representative, which advice I verily believe to be correct. 6. I attest hereto solely in the application to this honorable court to be released on warning, alternatively on bail, should the honorable court be so minded. 7. I intend tendering a plea of not guilty on all the charges preferred against me at the commencement of my trial, and submit that the evidence against me, both in this and the Moodley matter, in brackets, S versus Kuberethni, Moodley, and 12 others, case number SS76 of 2023, close bracket, is with respect extremely weak to being non-existent, and I endeavor to challenge same vigorously. 8. I am advised that the charges preferred against me fall under the ambit of Schedule 5 of the Criminal Procedure Act 51 of 1977, in brackets the CPA, and I am required to, in accordance with the legislative framework, more specifically Section 60, subsection 11, subsection B of the Criminal Procedure Act, adduce evidence which satisfies this honorable court that the interest of justice permits my release, having been afforded a reasonable opportunity to do so. I address the aforestated prerequisites further below, but first deal with the salient background facts relevant to this application and for the benefit of this honorable court. I then go on, Your Worship, to deal with a brief background, paragraph 9. I presently stand indicted in the Gauteng Division of the High Court, Johannesburg, as accused number 11 in the matter of S versus Moodley and 12 others, case number SS76/2023, the Moodley matter, which matter is set down for trial from the 2nd day of February 2026. 10. The Moodley matter is the subject of investigation by the Investigating Directorate Against Corruption, in brackets IDEC, i.e. the second respondent herein, and who has at all material times represented the state in these proceedings, in brackets including at its capacity as the Investigating Directorate, in brackets ID, of the National Prosecuting Authority, as it was previously known, under Johannesburg Central Case number 465/10/2019. To my knowledge, the investigating officer at all material times has been Lieutenant Colonel Denwil Reginald Kutsia. Paragraph 11. I was arrested in relation to the Moodley matter on 22 August 2022 after receiving a telephone call from Lieutenant Colonel Kutsia, in which he requested that I hand myself over on the morning before my scheduled court appearance before this honorable court, albeit differently constituted. I was subsequently arrested, charged, and admitted to bail on the self-same day. The state, as represented by the second respondent, did not oppose my bail, notwithstanding the matter falling within the ambits of Schedule 5 of the Criminal Procedure Act. 12. I was admitted to bail and understood my bail conditions as follows. 1. That I pay an amount of 50,000 rands as security, which amount I paid. 2. That I hand over my passport to the investigating officer, Colonel Kutsie. 3. That I am not permitted to travel outside the jurisdiction of South Africa without the permission of the investigating officer, which permission should not be unreasonably withheld. 4. That I provide my detailed travel itinerary to the investigating officer, who will return my passport for the purpose of international travel. 5. That I attend all my court appearances until the matter is finalized. Paragraph 13. I have since attended all my court appearances in the Moodley matter as directed by the Honorable Court. I have also, at all material times, fully cooperated with the second respondent. 14. With the acquiescence of the second respondents who temporarily released my passport, I traveled outside the jurisdiction of South Africa to Tanzania on business from 24 February 2024 to 2 March 2024. Upon my return, I returned my passport to the investigating officer. 15. I stand indicted on the following charges in the Moodley matter as per the most recent indictment dated 28 January 2025 and which is signed by the head of the second respondent, Advocate Andrea Johnson, a copy of which is enclosed herewith for the convenience of the court. 15.1, counts 1 to 8, fraud read with the sections of sections 103, 256 and 257 of the CPA in relation to the amount of 36,763,000. Alternatively, theft read with section 256, 257, 264 and 332 of the CPA in relation to the same quantum as the main counts. 15.2, count 9, fraud read with sections 103,256 and 257 of the CPA in relation to an amount of 79,230,000 rands. Alternatively, theft, read with section 256, 257, 264, and 332 of the CPA in relation to the same quantum as in the main count. 15.3, count 10, fraud, read with sections 103, 256, and 257 of the CPA in relation to an amount of 189,240,000 rands. Alternatively, theft, read with section 256, 257, 264, and 332 of the CPA in relation to the same quantum as the main count. 15.4, count 49, contravening section 86 in brackets 2, read with sections 1, 2, 3, 48, 50, 51, 55, 56, and 76 of the Public Finance Management Act 1 of 1999, in brackets the PFMA Act, read with sections 84 in brackets 3, section 256, 257, and 332 of the CPA in relation to an amount of 36,763,000 rands. 15.5, count 50, contravening sections 86, subsection 2, read with sections 1, 49, 50, 51, 55, 56, and 76 of the Public Finance Management Act, read further with sections 84.3, 256, 257, and 332 of the CPA in relation to an amount of 79,230,000. Paragraph 15.6, count 51, contravening section 86, subsection 2, read with sections 1, 49, 50, 51, 55, 56, and 76 of the Public Finance Management Act, read further with sections 84.3, 256, 257, and 332 of the CPA in relation to an amount of 189,240,000 rands. 16, the charges preferred against me in the Moodley matter ostensibly relate to the period when I served as the Group Chief Executive Officer at Transnet SOC Ltd, in brackets Transnet, and per the indictment relates to the period from April 2012, when Transnet launched the Market Demand Strategy, MDS, in achievement of South Africa's broader socio-economic objectives, which inter alia entailed creating value for Transnet through increasing the tonnage delivery and in shifting from road transport to rail transport, so to enhance the environmental footprints and job creation in relation to the procurement of the transaction advisory services for the 1,064 locomotives acquisition tender through a confinement process up to period June 2015. Paragraph 17, in paragraph 11 and 14 to 17 of the summary of substantial facts to the respondents inter alia, or rather the respondent inter alia assessed the following. I quote paragraph 11, on 7 May 2012, Gary Peter, accused number 5, submitted a memorandum to Brian Mulife, accused number 11, requesting approval for the appointment of service providers for the provisions of transaction advisory services related to the 1,064 locomotives acquisition tender through a confinement process. 14, according to the memorandum, the appointment of transaction advisors by way of confinement was solely based on the ground of urgency and was set out as follows. 14.1, the 1,064 locomotives were part of the plan to fulfill the MDS. 14.2, to meet the MDS, I beg your pardon. 14.2, to meet the MDS and corporate plan targets, the first tender was to be awarded in November 2012, and 14.3, as a result, Transnet had to immediately source transaction advisors to assist with all services required in pursuance of the 1,064 locomotives acquisition. 15, on 10 May 2012, Brian Molefe, accused number 11, approved the confinement process. 16, on 30 May 2012, Transnet issued a request for proposal in brackets GSM/12/5/0447 close bracket RFP for the appointment of transaction advisory services related to the procurement of the 1,064 locomotives. 17, on 26 July 2012, Transnet appointed McKinsey Consortium as transaction advisors to provide advisory services related to the acquisition of the 1,064 locomotives, I close quote. 18, in paragraph 77 to 92 of the summary of substantial facts, the respondent asserts the following. I quote paragraph 77. On 17 March 2014, Transnet awarded a contract to 4 bidders for the acquisition of the 1,064 locomotives at a value of 54.5 billion rands with the following original equipment manufacturers, in brackets OEMs. 77.1, China South Rail, 359 electric locomotives. 77.2, Bombardier Transportation, 240 electric locomotives. 77.3, China North Rail, 232 diesel locomotives. 77.4, General Electric, 2333 diesel locomotives. Transnet planned to finance the 1,074 locomotives acquisition by raising debt, that is, obtaining loans, which was divided as follows. 79.1, the China Development Bank loan. 79.2, the club loan. And 79.3, the interest rate SWAPS. 80, the proposed funding arrangement for the Bombardier transport component was done through Export Development Canada, and the General Electric component was done through the Export-Import Bank of United States. 81, on 29 April 2014, Ms. Makhatu wrote a memorandum to Brian Molefe, accused 11, and Anuj Singh, accused 12, to request approval for the Transnet Group Treasury to proceed negotiations with the China Development Bank for the funding of the China South Rail and China North Rail components. Anuj Singh recommended the request and Brian Molefe approved it. 82, in May 2014, Transnet Group commenced with the negotiations with the CDB regarding the financing of the locomotives to be procured from the Chinese suppliers. 83, during the post-tender negotiation phase, Regiment's Capital became involved in the negotiations on the CDB loan on instructions from Anuj Singh, accused 12, to assist Transnet Group Treasury. 84, Ms. Makhatu resigned as Transnet Group Treasurer, effective on 30 November 2014. After her resignation, the negotiations between Transnet and CDB came to a halt because of certain issues regarding the financing terms that could not be agreed. 85, on 1 March 2015, Petulo Ramusebudi, accused 7, was appointed as Transnet Group Treasurer, and the negotiations with CDB were revived by Eric Wood, accused 3, on behalf of Regiment's Capital. 86, on 16 April 2015, CDB sent an official mandate letter to Transnet that set out the terms and conditions on which they were willing to arrange the loan facility to 2.5 billion US dollars for Transnet to fund the acquisition of the 232 diesel locomotives and 459 electric locomotives. The letter provided indicative terms for the loan facility and formed the basis of the agreement between Transnet and CDB. 87, Brian Mulife, accused 11, signed the mandate letter on the same date, paving the way for Transnet to obtain a loan from CDB on less favorable terms than what could be obtained from other financial institutions. 88, on 17 April 2015, the former Minister of Public Enterprise announced that Brian Mulife, accused 11, was seconded to ESCOM with immediate effect. 89, on 28 April 2015, Petulo Ramusebudi, accused 7, compiled a memorandum to the Acquisition and Disposal Committee, which motivated the appointment in confinement of the JP Morgan Chase Bank, in brackets JP Morgan, and Regiment's Capital, accused 10, to conclude the CDB loan. The memorandum was recommended by Siyabonga Gama, accused number 4, Gary Peter, accused 5, and Anoj Singh, accused 12. 90, the recommendation requested for the ADC to approve the following. 90.1, the confinement appointment of JP Morgan to hedge the financial risk emanating from the 1.5 billion US dollars CDB loan back to South African rands. The confined appointment of JP Morgan to lead and underwrite the equivalent syndicated loan of 1.5 billion US dollars. 90.3, the contract extension from 99.9 million rands to 265.5 million rands for the appointment of Regiment's Capital, accused number 10, for transaction advisory services and support to Transnet on the 1,064 locomotives, and 90.4, delegated authority to Siyabonga Gama, accused number 4, to approve all documentation related to the confinement. 91, the request was approved by the ADC on 29 April 2015, and Anoj Singh, accused 12, was present in the board committee meeting. Anoj Singh failed to inform the members of the ADC that 91.1, Transnet Treasury team did most of the early negotiations. 91.2, the terms and conditions of the CDB loan were not favorable to Transnet, and 91.3, Anoj Singh did not notify the board about the exorbitant arrangement fees and interest that would cost Transnet an extra 3.7 billion rands over the loan duration. 92, on 3 June 2015, Regiment's Capital, accused 10, delivered an invoice to Transnet for a success contingency fee on their work towards the CDB loan, totaling 189,240,000, VAT included. 93, the CDB loan was signed on 4 June 2015, I close quote. Paragraph 19, paragraphs 101 to 112 of the indictment canvasses the 1 billion US dollar club loan and or 12 billion South African rands loan facility for the purpose of locomotives and respective of roles of inter alia Daniel Roy and Trillion Capital. 20, the second respondent is required to prove all of the above as it asserts in the indictment against some of my co-accused and I, who also now accused before this court. The above allegations contained in the second respondent's indictment against me relate specifically to the extent charges preferred me in the Moodley matter, and are moreover intrinsically linked to the new charges which the second respondent has decided to now prefer against me. 21, I was surprised to learn that the prosecutor in this matter, Advocate Santosh Minlan, who is also the prosecutor in the Moodley matter, called my attorney of record and advised that a decision had been made to charge me in relation to the acquisition of the 95, 100 and 1,064 locomotives. The ostensibly new charges are so intrinsically linked that any prosecutor or investigating officer acting rationally and reasonably would have added new charges against my co-accused and I in the Moodley matter, as opposed to initiating new charges against us, which are founded on the same factual and evidential matrix as the Moodley matter, and would, in the main, require many witnesses already listed as witnesses in the indictment in the Moodley matter. 22. Furthermore, in specific reference to the acquisition of the 1,064 locomotives, the Johannesburg High Court had in April 2025 set aside the decision of Transnet of January 2024, of 24 January 2014, awarding GE South Africa Technology Pty Ltd, known as WebTech South Africa Technologies Pty Ltd, the supply of 233 diesel locomotives and the locomotive supply agreement dated 17 March 2014. Notwithstanding, the High Court made a just and equitable order in confirming a settlement agreement reached between Transnet and GE South Africa Technology Pty Ltd as early as 8 November 2019, in brackets, and which was amended on 18 November 2022, I close bracket, to the effect that Transnet would retain the 233 diesel locomotives delivered by GE South Africa Technology Pty Ltd to Transnet pursuant to the locomotive supply agreement dated 17 March 2014, along with a settlement amount of 70,350,574 rands, whilst WebTech South Africa Technologies Pty Ltd would retain all amount Transnet had paid to GE South Africa Technology Pty Ltd under the locomotive supply agreement dated 17 March 2014. A copy of the order dated 14 April 2025 in the Transnet another versus CRRC E-Loco Supply Pty Ltd and others, case number 21/11645 is enclosed herewith for the convenience of the Honorable Court. In the premise there has been no prejudice, actual or potential or otherwise, to Transnet. It is evident that the charges preferred against me and my co-accused herein have its genesis in the Moodley matter, and that the second respondent, in representing the state, will place much reliance on many of the witnesses in the Moodley matter in its endeavors to prove its case against us in the ostensibly new matter now before this Honorable Court. 24, I submit with respect that I should never have been arrested in relation to these charges. The second respondent could simply have moved an application for the amendment of the indictment by adding additional counts or charges against me and some of my co-accused. The information in the second respondent's possession is not remotely new. It has had same in its possession for years. 25, I am advised that the state had failed to have regard to my constitutional fair trial rights, the interests of justice, the cost ramifications of a multiplicity of trials to both the state and my co-accused and I, the probable prejudice that may be occasioned to the state witnesses and I and my co-accused and our respective witnesses by subjecting us to a multiplicity of trials premised on the same facts, evidence, and witnesses. 26. I am furthermore advised that once the state has decided to institute criminal proceedings against me, any other decisions made or function executed in relation thereto are functions incidental to instituting criminal proceedings as envisaged by the provisions of Section 179, subsection 2 of the Constitution, and that such conduct is susceptible to the principle of legality and the rationality test. The decision to split or separate charges and the decision on whether to agree to or oppose bail are functions incidental to instituting criminal proceedings as postulated by Section 179(2) of the Constitution. 27. In this regard, I am moreover advised that the conduct of the second respondent is an egregious abuse of power and court process and will not withstand the scrutiny of the principle of legality and rationality test. 28. I am lastly advised on this issue that a prosecutor cannot act on the whims and dictates the investigating officer, but has a duty to evaluate evidence, the alleged charges, the course of conduct and action, the witnesses, the court, the interests of justice, the position and circumstances of the accused, the victims of crime, and fair trial rights of an accused when exercising his discretion under Section 179, subsection 2 of the Constitution. 29. To this end, I respectfully submit I should, as a matter of fact, not be applying for bail today as I had previously applied for bail on the genesis of the same facts, evidence and witnesses that the state intends placing reliance on in the Moodley matter. Both the prosecutor and the investigating officer failed to have regard hereto when the decision was made to charge me ostensibly on new charges, premised on the same facts, evidence, and witnesses, and when deciding not to oppose my bail, but instead proposing an extraordinary and shockingly disproportionately high amount of bail, which in effect amounts to opposing bail. 30. In the premise, I humbly request the Honorable Court, should the Honorable Court be so minded, to release me on warning, which I am advised is reasonable under the unique circumstances of this matter, and in having regard to all the facts. Personal circumstances, family background, and personal background. Paragraph 31. As stated herein, I am a 58-year-old adult male and South African citizen, permanently residing at house number 7, The Ridge Street, Zwafel's Nest Estate, Zwafelpoort, Pretoria, where I reside with my wife, Mrs. Aretha Haundibali Mulife, one minor child aged 10, 2 adult children aged 28 and 18 respectively, all of whom I support. I am also a father to another adult child aged 24. I have been residing at the aforementioned address for the past 4 years and 8 months. Prior thereto, I resided at 409 Kelly Bray Lane, Cornwall Hill Estate, Irene. I resided at that latter address for a period of 5 years. 33. In addition to the above, with effect from August 2024, I also reside at Acacia Park Parliamentary Village during parliamentary sessions as a direct result of my employment, which is situated at Townsend Street, Goodwood, Cape Town. 34. I was born in Pretoria, South Africa, on 28 December 1966. I lived with my parents and 3 siblings at 2695 Zone 2, Garankuwa, where my mother continues to live. The house property is unencumbered and is owned by my elderly mother. My father and 1 brother both passed on in 2018, May and December respectively, and are buried in Pretoria. 35. I matriculated at Botswana High School in Mahikeng, Northwest Province in 1984. I left South Africa between 1993 and 1994 to study for a postgraduate diploma in economics in the United Kingdom. I returned to South Africa at the end of my studies there. All my degrees were obtained at the University of South Africa. 36. I have left South Africa several times to attend executive programs at numerous universities, inter alia, Harvard Business School, Massachusetts Institute of Technology, and Wharton University. I have returned to South Africa at the end of each program. 37. I have spent my entire working life in South Africa, mainly in the civil service, and have never worked outside the country. 38. I have a total monthly net income of approximately 99,776 rands and 47 cents, comprised of my monthly net salary I earn as a member of parliament. In brackets, that amount is 44,046 rands and 18 cents, and a monthly pension of 52,730 and 47 cents. I am the breadwinner in my family, and everyone who resides with me depends on me and whom I provide with financial support, food, clothing, and shelter. I am also responsible for the school fees of 17,750 rands per month for my minor child and for one of my adult children. My monthly electricity bill for my permanent residence is 15,000 rands, whilst the levy is 5,000 rands per month and my insurance is 7,000 rands per month. I pay the monthly medical aid premium for me, my wife, and my minor child, and my one adult child who is still studying. 40. The household costs, which include food at my Pretoria residence, is approximately 10,000 rands per month. I am also responsible for the payment of the domestic servant at my Pretoria residence and the farm hands at the farm which I own in the amount of 15,000 rands per month. Whilst the farm is not presently financially productive, I also spend approximately 3,000 rands per month on feed for the animals. 41. I spend approximately 4,000 rands per month on fuel, 3,000 rands monthly on telephone and internet costs, while I also spend approximately 3,500 rands per month on food and household costs at my Cape Town address. 42. My elderly mother, who does not reside with me, is also dependent on me. In this regard, I am responsible for her medical aid in the amount of 1,500 rands monthly and her sustenance, electricity, water, and her domestic helper in the amount of 5,000 rands. Should the Honorable Court not accede to my prayer to be released on warning, I am able to afford an amount of 20,000 rands as security in lieu of bail. 44. I have a close-knit family with strong values and roots whom I remain deeply committed to and whom I all deeply love and care for. I have no desire to relocate, uproot, or flee, and value my family environment, the foundation, love, and support. I also do not have any inclination to inconvenience or disrupt my family. To this end, I have it plain in this matter that in the Moodley matter that I intended pleading not guilty and will vigorously challenge the charges preferred against me. As I have no intention whatsoever to evade justice, I very much intend standing my trial. 45. I also do not have any relatives outside the border of South Africa, neither do I own any property outside South Africa, and am neither presently engaged in any business initiatives or investments outside of South Africa. I also do not have any monies or bank accounts outside of South Africa. Medical condition. 46. I suffer from the following chronic medical conditions for which I am required to take medication daily and to which I do. 1. Diabetes, 2. Hypertension, and 3. Arthritis. Qualifications and employment. 47. I hold the following post-matric qualifications. 1. Bachelor of Commerce, or BCom. 2. LLB. Bachelor of Laws. 3, postgraduate diploma in economics. 4, Master of Business Leadership, MBL. 5, Master of Laws, LLM. And 6, Doctor of Engineering. I am presently a registered student and reading towards a Doctor of Laws, LLD, at the University of South Africa with student number 5918561. 49, I am employed as a member of the National Assembly for the Umkhonto weSizwe political party and have been since August 2024. Assets, paragraph 50, I own the following assets. 1, house number 7, The Ridge Street, Zwafel's Nest Estate, Zwavelport. 2, portion 24, a portion of 21 of Farm Woodstock, 397. 3, an Audi A4, a Nissan Navara, a Ford Bantam, as well as a Nissan Micra. Passport or traveling documents. 51, I am a holder of the South African passport, which I have already handed over to Lieutenant Colonel Kutsie as per my bail conditions in the Moodley matter. Previous convictions. 52, the provisions of section 60, 11 capital B, subsection A of the Criminal Procedure Act have been explained to me by my attorney of record. I understand that everything I state in this affidavit is admissible as evidence in any subsequent proceedings. I further understand that I am obliged to fully disclose all of my previous convictions and pending cases, and that failure to do so or supply false information in this regard is a criminal offense. 53, I do not have any previous convictions. 54, as stated earlier herein, I am accused number 11 in the case of Moodley matter, wherein I have been admitted to bail in the amount of 50,000 rands. My passport was also handed to Lieutenant Colonel Kutsie, the investigating officer in the Moodley matter. I have diligently attended all the hearings and observed all the bail restrictions related to that matter since my arrest on 22 August 2022. Currently, the matter has been postponed for hearing in the Gauteng High Court sitting in Johannesburg to 2 February 2026. 55, I have not committed any offense while on bail and have not supplied any false information to the second respondent or members of the South African Police Service at any stage, and I commit myself to cooperate fully with the investigating officer at all times, and I have been the interest of justice, where we go on to address the section 60, subsection 4A. It's stated as follows: section 60, subsection 4, subsection A of the Criminal Procedure Act, no likelihood of endangering the safety of the public or any person. There is absolutely no likelihood whatsoever that my release on bail will endanger the safety of the public or any person, nor is there any likelihood that I would commit Schedule 1 offense. 57, I moreover do not have any propensity to commit crime. Subsection 60, section 60, subsection 4B of the Criminal Procedure Act, which deals with the likelihood of evading trial. 58, there is no likelihood whatsoever of me evading justice, not to stand my trial, or attempting to evade to stand my trial. 59, I intend to attend all court proceedings to defend my innocence and my fair trial rights vigorously, and I have no desire to evade justice. 60, my strong family ties, roots, and values are delineated herein above. I am the main and only breadwinner, and my family is dependent on me, and to stand to be severely and substantially negatively impacted should I not be released on warning, alternatively bail. 61, I have no family ties outside of the country, and my passport is in the possession of the investigating officer in the Moodley matter. 62, I have also fully cooperated with the authorities, and so have my legal representative. 63, crucially, I have demonstrated my adherence to bail conditions by traveling outside the country and returning within the timeline I had advised the authorities and in accordance with my itinerary. I furthermore returned my passport to the investigating officer within the agreed upon timeline upon my return to South Africa. 64. I am thus able and willing to adhere to any condition the Honourable Court wishes to impose on me in consideration of my release. Section 60, subsection 4C, the likelihood of influencing or intimidating any witnesses. Paragraph 65. Aside from the intrinsically linked evidence discovered to me in the Moodley matter, no evidential disclosure has been made to me in this matter to date. 66. I have not intimidated any witnesses in the Moodley matter and have no desire to do so. There is thus not any remote likelihood that I would influence or intimidate any witnesses or attempt to do so. Neither is there any likelihood of me concealing and or destroying any evidence, nor attempting to do so. 67. In this regard, I have also not displayed any degree of violence towards anyone. Neither have I threatened anyone with violence, nor have I displayed or harbored any resentment against anyone. Section 60, subsection 4D, which deals with the likelihood of undermining the objectives of the criminal justice system. Paragraph 68, there is no likelihood that my release on bail would undermine or jeopardize the objectives of the proper functioning of the criminal justice system, including the bail system. 69, I have demonstrated an unblemished record of adhering to conditions imposed on me and by attending all my court appearances in my pending matter. 70, I moreover intend to challenge the charges preferred against me vigorously and vindication of my innocence. Section 60, subsection 4E of the Criminal Procedure Act, paragraph 71. Lastly, there is also no likelihood that my release on bail would disturb the public order nor undermine the public peace and or security, the interest of justice. Paragraph 72. The process that will be involved in getting this matter ready for trial and the finalization of this matter is probably likely to take many months, if not several years, to complete if regard is had to the duration the second respondent has taken to bring the intrinsically linked Moodley matter to trial since my arrest and admission to bail on 22 August 2022. It will not be in the interest of justice to keep me incarcerated during this prolonged period. 73, setting the bail amount too high and out of my reach will be tantamount to refusing me bail and will condemn me to prolonged incarceration. I submit that this will not be in the interest of justice, as bail should not be used to punish me or anyone. 74, my likely prolonged incarceration as a result of possible delays in the conclusion of this matter will result in my inability to execute my responsibilities as a member of the legislative arm of government and will also lead to substantial personal financial losses. As an elected representative to Parliament, I will be unable to attend to my duties, contribute to lawmaking, and vote on critical decisions that require elected representatives to express the will of those that have elected them, impairing the proper functioning of our democracy. 75. Moreover, my continual and or prolonged incarceration will also financially and substantially prejudice members of my family, as I am the main breadwinner. 76. I am 58 years old and constantly require chronic medication and a special diet for my medical conditions. Conclusion, paragraph 77. I humbly submit to the Honourable Court that all circumstances described above herein individually and cumulatively demonstrate that it would be in the interest of justice for this Honourable Court to release me on bail, should the Honourable Court not be so minded to release me on warning. 78, I am able to raise and tender an amount of 20,000 rand in lieu of bail, along with any bail conditions that the Honourable Court may impose on me. 79, wherefore I pray for the favourable grant of the relief sought as per this application. As I've indicated, Your Worship, the affidavit has been properly commissioned, and I beg leave that it be admitted as Exhibit D to the record. As a copy.
Mr. Monifer, do you confirm the contents of the affidavit which was read and everything supported the bail application?
Do you confirm the contents of this affidavit which was read by your counsel?
I do.
Thank you. It's accepted. And marked Exhibit D.
As a copy.
Thank you. Mr. Ulrich, do you want to, is there anything? Do you want to state
Given the
anything?
approach by the state, I have no address and ask that we have the conditions as suggested.
Thank
imposed
you.
As you wish.
Thank you. Mr. Small,
Also, have no further address, Your Worship.
thank you so much. Ms. van der Heever?
My Lord, we do indeed wish to address the court on a number of issues. I have indicated to the Honourable Court that I'm going to address the court on the current income of the accused. My Lord, Your Worship, without setting it out in detail, I can place on record that the amount that's currently being earned by the applicant barely cover his living cost. That is, you can quite easily see from what is set out what cost he needs to cover. I then wish to move to the issues that we've dealt with in paragraph 49. And I want to make the following submissions to Your Worship. Your Worship has already been addressed or have taken notice of the correlation between the case before you and the case that is due to start in February of next year in the High Court. As we've indicated, this is actually an extension of the same case. The witnesses that the state intends to call in that matter very much overlap with the witnesses that the state intends to call in the matter at hand. I have very quickly perused the charge sheet that we've been given this today, and I've made the following notes. Count 1 is a charge related to the PMFA. Count 3 PMFA. Count 6 PMFA. Count 9 PMFA. Count 2, 4, 7 relates to Companies Act offences, and then what we have in respect, then we have the issue of the fraud charge in count 4, and count 10 is a corruption charge where that relates only to accused number 1, and then counts, I know my learned friend changed it per hand, he said count 11 to 13, but you have, if you actually have regard to the body of the case, it's count 12, 13 and 14. Now the issue is the following, Your Worship, and that is the affordability of the bail in this particular case is, I respectfully submit, what needs to be decided by this Honourable Court. The state suggested an amount of 200,000, and since Friday there's been discussions between the defence and the state pertaining to this particular amount. The fact is that if the applicant cannot raise the 200,000 suggested by the state, the court, and if this court is so inclined to in fact agree to the 200,000 rand, it will effectively mean that the applicant will have to stay incarcerated, and the court will effectively deny him bail. Now know, and I've got no doubt with your worship's experience over many, many years, that the issue of the amount of bail is an aspect that can be dealt with by this court separately. What is common cause here, your worship, is the personal circumstances of the accused, his history as a person, and his conduct since he was released on bail in the High Court case. He adhered to all the bail conditions on which he was released. In fact, he's travelled abroad on numerous occasions, and on each time he's returned. So the state does not regard him as a flight risk. That is a given, and the court must accept that from the word go. Look, we then deal with the issue of what we respectfully submit is the infringement of his constitutional rights if the court is not inclined to deal with the issue of bail, as I respectfully submit we're going to address the court on. He is entitled, as the court notes, to be released on bail or released from detention subject to any reasonable conditions. That's 35(1)(c). And he is entitled to be regarded as innocent, 35(3)(h), and then is entitled to argue the issue of the lawfulness of his continued detention before a court. Now, this brings me to the issue of the submission that I wish to make to the court pertaining to the manner in which the applicant was brought before court. And I'm going to respectfully submit to the court that this court are entitled and should take cognizance of the relevant case law that deals with this particular aspect. This is a court that's competent to take notice of that, and this court is competent to apply the relevant case law. Now, it's trite that the state, when it decides to bring somebody before court, needs to apply one of the manners that's set out in section 38, and that is arrest, summons, written notice, or by way of an indictment. We then deal with section 54. We know that you can summon somebody to court, and there is no limitations on what kind of matter the court, or on what kind of matter a person can be summoned to court. We then have the various cases, Your Worship, where this issue has been dealt with. And the reason, this is almost, I have to put the cart before the horse, the reason why I wish to address the court on that is because of the fact that this case law, I respectfully submit, should influence, Your Worship, on the issue of whether you are entitled to, and I submit should, release the applicant on bail or on a suitably lesser amount. And I will lastly address the court on the issue of the suitable lesser amount. Now, the case of, I have sent my learned friend all of these cases. Now, the first case I wish to refer, and that is actually the case currently that is the most important case, is the matter of Lowe and another versus the Minister of Safety and Security and another. It's a matter that was decided in 2002.
Your Worship, I object at this stage. My learned friend, firstly, she has just made a statement now that she's sent me all of these case law, etc. That is not true. I have not received such case law. And my learned friend is going into an argument now. I'm not sure where she's going with the argument. We are dealing with an issue of a bail application, but her submissions that she's making now, bringing in the fact that the accused should be released on summons. This is a Schedule 5 offence which he has accepted. There's no dispute about this being a Schedule 5 offence. If it's a Schedule 5 offence, there was a warrant issued, the warrant was executed, and hence the accused were in custody and brought to court. Where does the issue of summons come into the picture on a Schedule 5 offence? So I'm not sure in what angle my learned friend is going, And if it's an inquiry relating to the quantum, the amount of bail that should be issued, then these submissions being made, surely it should be made by way of an inquiry, because we're going to have to go into detail. How do I accept that? How do I oppose that? I'm not in a position to do that. So if my learned friend wants to deal with that, we're going to have to deal with that by way of an inquiry. And I do not believe that if that is the position, that her client's bail application can be finalized today. Thank you, Worship.
Your Worship, my learned friend maybe misunderstands the issue that I'm approaching. What I'm trying to submit to the court, that these processes that can be followed, and one of those processes that a summons can be issued. There's nothing that does not permit, based on certain factors, that the state can issue a summons. In fact, my learned friend, during our conversation on Friday, said it was one of the options that the state considered before the warrants of arrest were done. I accept. There is a warrant.
Objection, Your Worship. This is why my learned friend wanted to engage with me over the weekend, and I stopped that, because this is exactly what I despise. It's not a he said, she said. I would have never suggested that, knowing that a warrant, a warrant of arrest has been authorized by a magistrate. How can I then talk about a summons, knowing well it is an irregular process? A summons is an irregular process for a Schedule 5 offence.
Ms. Panagiosa, this is my position. All you do is convince the court to grant a reasonable amount of bail to your client. That's all. That's forget about the rest of it.
I'm quite happy to deal with it in that matter. We cannot afford 200,000. We've made it clear, Your Worship. If there was a number of processes that could have been followed, what we can afford at the most is an amount of 50,000 rand. And that amount literally had to be urgently acquired over the weekend from other sources.
That's fine. I think that's enough.
May it please the court.
May it please the court, Your Worship. When I handed up the affidavit, I omitted to hand up the annex charge. May I do so? I beg leave for the court to do so. As it please the court, Your Worship. Your Worship, as far as the address on behalf of accused number 2, Mr. Molefe, is concerned, it's common cause that we have agreed it is a Schedule 5 bail application, and the onus is upon him to adduce evidence, Your Worship, to convince this honorable court that the interest of justice permits his release on bail. When I followed the court's direction to my learned friend that was addressing you before me, what your worship emphasized is the issue of the bail amount. Your worship, in the circumstances, we submit that a bail of 200,000 is out of reach of Mr. Molefe. He will not be able to afford that, taking into account the length of periods where he's been unemployed, and in line with the decision of State v. Mohammed, 1977, Volume 2, SA 531, where the court held the following, I read, "The means and resources of an accused are therefore important, although not the sole criteria in fixing the amount to be paid." Hence, speaking very generally, I think that if a court is minded in all circumstances to release the accused on bail, it should not fix an amount that is quite beyond his means and resources. Otherwise, that would nullify its decision to release bail. Hence, I close quote, hence we submit, Your Worship, that at this current moment, Mr. Molefe can only afford bail amount of 20,000 rands. However, as indicated in his affidavit, we submit that due to the fact that he is not a flight risk, he has left South Africa, he has come back, his passport is in the possession of the investigating officer regarding the Moodley matter, and he hasn't shown any propensity to commit Schedule 1 offences or to evade trial. A release on warning would be just and equitable. However, if the court is not so minded, my lord, then an amount of 20,000 rands will do in the circumstances. Those are our submissions. Unless if the state will raise other issues that will require us to respond, those are our submissions. As a court basis.
Thank you, Your Worship. Your Worship, for the state, the investigating officer, Captain Willem Roelbukes, has prepared an affidavit. May I have leave to read out his affidavit into the record, Your Worship? I hand in the original commission affidavit, and I request that it be marked as Exhibit E.
Your Worship, we've not had an opportunity, neither will be given this affidavit beforehand to peruse.
Your Worship, I do have copies available.
May I please?
May I proceed, Your Worship? I, the undersigned, Willem Roelbukes, do hereby make oath and state as follows. I am a captain in the South African Police Services, stationed at the Directorate for Priority Crime Investigations, abbreviated as DPCI, and attached to the Serious Economic Offences Unit. I am currently designated to the Investigating Directorate Against Corruption of the National Prosecuting Authority, situated at Linton House, Brooklyn Bridge Office Park, Brooklyn, Pretoria. I am a member of the SAPS appointed in terms of the South African Police Services Act, Act 68 of 1995. I perform my duties in terms of Section 30 of the SAPS Act, read with Section 205, subsection 3 of the Constitution of South Africa, Act 108 of 1996. The facts deposed to herein are derived both from the documentation at my disposal and from my personal knowledge, unless I state the contrary or the context indicates otherwise. They are, to the best of my knowledge and belief, both true and correct. The investigating director, as the head of IDAC and in terms of Section 28(1) of the National Prosecuting Authority Act, authorized an investigation into allegations of the commission of offences such as fraud, corruption, money laundering, and contravention of the Public Finance Management Act 1 of 1999, relating to the awarding of tenders by Transnet as follows. 5.1, the procurement of 95 electric locomotives. 5.2, the procurement of 100 electric locomotives. 5.3, the procurement of 1,064 locomotives, and the costs relating to the relocation of the production assembly lines of the two original equipment manufacturers to Durban. Paragraph 6, I am designated in terms of Section 28(2) of the National Prosecuting Authority Act, Act 32 of 1998, to investigate the allegations referred to in paragraph 5. The accused in the above matter are Anod Singh, Brian Molefe, Siyabonga Gama, and Tamsankwe Giana, and they are charged with offences which are mentioned in Schedule 5 of the Criminal Procedure Act 51 of 1977. I confirm that I personally, telephonically contacted each of the accused between 4 p.m. and 9 p.m. on the 26th of June 2025. I requested that they present themselves at the Buckendowns Police Station in Alberton on Monday, 30th of June 2025 at 8 a.m. for their arrest. They all confirmed that they will present themselves as requested. I have verified the addresses of each of the accused persons and confirmed that the addresses are correct. I have profiled each of the accused, and I confirmed that there are no previous convictions or pending warrants. However, Anod Singh, Brian Molefe, and Siyabonga Gama were previously arrested for a criminal case under Johannesburg Central, CAS 465/10 of 2019. The investigating officer of the docket is Colonel Kutsia. This case is currently on the roll before the Johannesburg High Court under case number SS 76 of 23 in the matter of State versus Kubendran Mudli and 12 others. I have confirmed with Colonel Kutsia that they are currently released on bail in the amount of 50,000, each with stringent bail conditions, and that they have adhered to their respective bail conditions and attended all court appearances. The last date of this appearance on this matter was the 25th of March 2024, and it was postponed to the 2nd of February 2026 for purposes of trial. I am not opposed to bail being granted for the accused. The reasons for the decision not to oppose bail are as follows, as set out in terms of Section 62, subsection D of the Criminal Procedure Act. 11.1, there is no reason to believe that the accused would endanger the safety of the public or any specific person. 11.2, that there are no reasons to believe at present that the accused will evade their trial. 11.3, that there are no reasons to believe at present that the accused will intimidate or influence witnesses or that they will destroy evidence. And 11.4, there is no reason to believe at present that the accused will undermine or jeopardize the criminal justice system. Paragraph 12, I am therefore of the respectful opinion that in the interest of justice permits the release of the accused on bail. 13, the offences with which the accused are charged include charges of fraud while acting in the furtherance of a common purpose. The state therefore requests that the court, when considering a reasonable amount of bail to be set in terms of Section 60, subsection 2B, A and B, to consider an amount in relation to the amounts involved and the seriousness and the gravity of the offences. I have confirmed with Colonel Kutsia that Anoj Singh, Brian Molefe, Siyabonga Gama handed in their passports as part of their bail conditions on this matter. This affidavit was signed at Brackensdown on the 30th of June 2025. It was commissioned before Commissioner of Oaths also on the 30th of June 2025. Your Worship, may it be accepted as Exhibit E. Yes, thank you, Worship. Yes, Your Worship. Firstly, I would like to make it very clear to my learned friends who have not, at this point, been placed in possession of the docket in relation to this matter. So in essence, my learned friends for accused number 1 and my learned friends for accused number 2 do not know the evidence that is going to be presented in this trial. Their speculation and assumptions on this matter that it is connected and relates to the matter involving case number SS 76 of 2023, Your Worship, I submit with respect, is flawed at best. Without having the evidence on this particular matter, how can they compare it with the evidence on that particular matter? They cannot do that. And it is mere speculation based on what they know on the transactional advisory matter, and what they have seen is by the mere mention of the 1064 locomotives. They are making all the assumptions that it is connected. Your Worship, the transactional advisory matter is a separate matter. It was a separate contract. It was the procurement of the transactional advisors on confinement. What resulted from that contract was then the acquisition of the 1064 locomotives. But further than that, Your Worship, in this particular matter, we are dealing with the acquisition of the 95 locomotives. We are dealing with the acquisition of the 100 locomotives. We are dealing with the acquisition of the 1064 locomotives, and flowing from that is the relocation of 2 original equipment manufacturers to the Port of Durban. But further than that, there are also corruption charges being preferred against the accused before court. Those corruption charges are not the corruption charges that the accused are facing on transactional advisory. So, Your Worship, the contracts that we are charging the accused on is totally separate from the matter relating to transactional advisory. Yes, it stems from the transactional advisories, the advice provided in respect of the loans on the transactional advisory matter, which led to the procurement for the 1064 locomotives. But to say that it's the same evidence, same witnesses, Your Worship, I submit with the greatest respect, it's a flawed argument. I know the evidence for the state. We are dealing with this particular docket, so I can give the court an assurance that these are different contracts that the accused have been charged for. So, Your Worship, I think without making it an issue, and if my learned friend accepts this, we can dispense with that argument, because that will now have to, and she has remedies regarding, my learned friend has remedies regarding that, whether she wants to bring an application relating to the defectiveness of the charge sheet. They can do that. But if she's prepared to move on with this bail application, then I'm going to make submissions with the leave of the court relating to the reasons why the state has suggested certain quantums, an amount that the state has suggested for bail in respect of the respective accused. So, Your Worship, it is true that once the warrants were authorized, that the investigating officer did contact the legal representatives of the accused and indicated for them to present themselves in court on today. And my number was also provided to the legal representative, because they could engage with me regarding what I would be suggesting as a reasonable amount of bail. Your Worship, I did indicate to them what I suggested as a reasonable amount of bail, and I did that in respect of accused number 1, 2, and 3. I suggested an amount of 200,000 rands with certain conditions. In respect of accused number 4, I suggested an amount of 100,000 rands with certain conditions. Your Worship, it's quite ironic at this stage, if I may say so, and I say so with respect, that accused number 1 and accused number 2, who, by virtue of the way they are presented in court as accused number 1, accused number 2, accused number 1 of the 4 accused faces 19 counts. My learned friend has just mentioned 1 count of fraud, but in fact faces 2 counts of fraud. Accused number 2 faces, Worship, if Your Worship will just bear with me. Accused number 2 faces 9 counts, and the counts relate to contraventions of the PFMA, the contraventions of the Companies Act, fraud and corruption. Accused number 3 faces 5 counts, compared to the 13 counts that accused number 1 is being charged with. And accused number 4 faces 2 counts. I might have made a mistake initially regarding the counts for accused number 1. Accused number 1 faces 13 counts, ranging from PFMA transgressions. There are 4, 3 Companies Act transgression, 2 counts of fraud, and 4 counts of corruption. To be clear, accused number 2 faces 3 counts of contraventions of the PFMA, 3 counts under the Companies Act, 4 counts, 2 counts of fraud, 1 count of corruption. In respect of accused number 3, 1 count under the PFMA, 2 counts of fraud, and 2 counts of corruption. In respect of accused number 4, 1 count of fraud and 1 count of corruption. Your Worship, it is my submission that accused number 3, and as presented by my learned friend, has accepted the amount that has been suggested, in that being 200,000 rand. And I submit with respect that he understands the gravity of this matter. Hence, he would not have agreed to such a quantum. The charges against the accused, Your Worship, to justify this amounts that I have suggested. Number one, it's the profile of the accused and the positions they held at the time of the commission of the offence. Accused number one was the group chief financial officer at the time. Accused number two was the group chief executive officer at the time when all of these offences were committed. So they held very prominent positions and profiles at Transnet at that particular time. And accused number one and two being members of the accounting authority as defined in the Public Finance Management Act. They had a duty of care. They had to act honestly and with integrity. Your Worship, further than that, besides their positions, the seriousness of this matter, it involves three contracts, essentially. The acquisition of the 95 locomotives, the acquisition of the 100, and the acquisition of the 1064. Your Worship, in terms of the values of those contracts that Transnet eventually paid in terms of those contracts is astronomical. So in respect of the 95 locomotives, Transnet eventually paid an amount in excess of, Your Worship, if you would just bear with me a minute. I have these figures noted down. In respect of the acquisition of the 95 locomotives, Transnet paid an amount of 3.4 billion. And this amount exceeded the original approved contract by 231 million. That was the first contract. The second contract related to the 100 locomotives. Transnet paid an amount of 5.1 billion, which exceeded the original contract value by 348 million. In respect of the 1064 locomotives, and specifically the acquisition of the 369 locomotives, Transnet paid an amount approximately of 16 billion. So in essence, in terms of these three contracts, cumulatively, Transnet paid an amount in excess of 25 billion. In respect of the relocation matter, Transnet paid an advance payment of 368 million. With the initial proposal from the original equipment manufacturer starting at 9 million, it escalated to 347 million, from 9 million to 647 million. An advance payment was made in the amount of 368 million. Your Worship, in terms of the seriousness, I think the figures speak for themselves. And as I indicated, that it's ironic that accused number 1 and 2 will suggest to this court on a Schedule 5 offense that they be released on warning. Your Worship, it is my submission that the amount that has been suggested by the state, and I know that one does not have to look at the amount of the offense versus what amount the court, in the court's discretion. However, it is in this particular matter, it is a serious consideration that I ask Your Worship to consider. Your Worship, further, one has to consider the means within which the accused can afford and pay the bail, and weigh that up against the seriousness of this case. Your Worship, I might be bold enough and respectfully submit that Your Worship can take judicial notice of the impact that these three contracts have had on Transnet, which has ultimately affected the country. I'll leave it at that point. Your Worship, I submit that, yes, the accused have been released on bail on the previous matter, and that they have adhered to the conditions. They've traveled overseas. The state has no dispute about that, and hence the state has agreed to the non-opposition of the bail. However, the state is suggesting bail in these amounts to mitigate the risk of them absconding. So the cards are stacking up against the accused. They are out on bail on the previous matter, and then they have this matter with serious, this is the second serious commercial crime case for which they're being charged. So the cards are stacking up against the accused, and therefore the state has set an amount to act as a proverbial sword over their heads to secure their attendance and to mitigate their risk of absconding. Your Worship, unless Your Worship would like to hear me on anything specifically, that's the address for the state.
Your Worship, given that we were favoured with this affidavit by the investigating officer, I deem it necessary to perhaps, as a matter of record, simply record the following. It is incorrect to suggest, as my learned friend for the state does, that there's an acceptance. It doesn't matter what it is that the defence agrees with the state insofar as these conditions are concerned. What matters is what Your Worship decides to be the appropriate condition. In this instance, what seems to be in contention is, as my learned friend refers to it, the quantum that the accused in the amount are required to deposit as bail. A careful consideration of my client's affidavit makes it apparent that that is what he has access to. It's not what is agreed, because one would have wanted to consider what appears in paragraph 11 of the investigating officer's affidavit. I didn't have that, regrettably, prior to my learned friend addressing the court in argument. But what we see in this paragraph is nothing other than what is ordinarily enumerated in section 60, subsection 4, subparagraphs A to E. And those are the factors that Your Worship is required to have regard to when it comes to a consideration as to whether the applicant is a good candidate or otherwise to be admitted to bail.